Welcome to today's conversation about how to bring a victim's voice into the courtroom in our intimate partner violence cases. I'm really excited to be here along with my colleague, Jonathan Kurland. Hi. We're both attorney advisors with AEquitas. We are funded through various grants to provide the field, prosecutors and allied professionals with innovative, informed, and hopefully really practical strategies to improve their response to intimate partner violence cases, also sexual assault cases and human trafficking cases. So a little bit broader than just intimate partner violence. You can learn more about what we do by visiting our website. You'll see some public-facing resources like webinars, training series like this one, some written resources as well. We conduct training events live around the country, a lot by Zoom these days. We're also available to do 24/7 consultations. So if you need a sounding board, you want to walk through some, case-specific strategies or have us conduct some research on your behalf, we're happy to do that. You can reach out technically 24/7 via email or our phone line. We're also engaged with several partnerships and initiatives that are rolled out on a national level, including the Sexual Assault Kit Initiative, the Enhanced Collaborative Model Human Trafficking Task Force Program, and the Innovative Prosecution Solutions grants that are awarded to different prosecutors' offices around the country doing really innovative work. So proud to be doing that in partnership with many of you probably on this call. Feel free to follow us on any social media platform that you're comfortable with in a professional capacity. We're pushing out resources, training opportunities, and funding opportunities on a regular basis through our social media. You can also always check out our website for new announcements of things like that. This work today is supported by our grant awarded from the Office of Violence Against Women, the U.S. Department of Justice. We want to thank them for their support and let you guys know that not everything we say is necessarily reflecting the reviews of the Department of Justice. In our effort to make sure that you get the most innovative and informed strategies, we often pull from the latest research and other experts in the field, and we will share that with citations and proper acknowledgement, and we do that under our fair use doctrine. So today, as we chat, John and I want to kind of introduce the world of evidence-based prosecutions and how we can be the most successful putting those together, hopefully from the beginning. Talking about one of the key ways to do that is to litigate the admission of statements. What statements can come in under various exceptions to hearsay and looking at Crawford, and then the use of experts that can help bring the victim's voice into the courtroom through them educating the fact finder. So let's get started, John, because this is a lot to be covering today. So I'll warn people on that. But let's start off with, what does it mean to conduct an evidence-based prosecution?
Well, thank you, Jane. And with the time pressures, I'm going to be very conscious of not trying to speak too fast. But I have to begin. Of course, I always note, I hate this label of evidence-based prosecutions, and I hated it as a prosecutor because, of course, what do you mean evidence-based prosecution? All my prosecutions are based on evidence. Why single out a specific kind? Nevertheless, this is the nomenclature we use, and so this is what we're going to apply. And generally, I think what we mean in terms of an intimate partner violence context is that an evidence-based prosecution is a prosecution that can be conducted regardless of whether the victim is able to participate in the investigation or the prosecution, whether or not they're able to testify, and even if they may be recanting and or minimizing what we think is the actual account of what happened during the episode of domestic violence.
Mm-hmm. And I know we talk about collaboration all the time, so I just want to do the foundation here as well, that these cases in particular, if we're proceeding with an evidence-based prosecution, and I noted that the term is a little off off target, but that the collaboration is particularly important in these cases. And while we're this little prosecution piece, we can't do these without the others.
Absolutely. Evidence-based prosecutions, and I'll use that terminology with and note my reservations throughout. But the collaboration, these are tougher cases by their nature than when a victim is able to participate or a victim hasn't been lost through attrition. So that's why collaboration and building a network of collaboration in your jurisdiction is so critical, because collaboration with victim services, with law enforcement, it's going to be a force multiplier for what we're doing. And we address that in some of the other portions of the series. I'm not going to unpack it more deeply here unless I'm specially requested to do so.
I have a feeling it'll come up again in the course of our conversation.
Well, it comes out throughout. Yeah, it's always the underlying context. So yeah, probably.
Because like looking at these key strategies, like each one of these necessarily involves, or would be enhanced by the involvement and collaboration with our partners. So let's walk through some of these key strategies of how we can prepare ourselves from the very beginning to have that case at the end that we can present effectively, even where we don't have a victim able to participate.
Sure. Well, we just talked a little bit about the cases that don't have victim participation. They're going to be more challenging. And in response to that challenging, there's no sugarcoating it. We need a more holistic effort at all traffic points within the case. This includes with investigations. And I think probably the most idealized evidence-based prosecution is going to be the domestic violence homicide. And ideally, the kind of effort that most jurisdictions commit to a homicide are going to be the kind that can be committed to almost every incident of domestic violence. That's not always possible given resources in a jurisdiction that's recognized and conceded, but trying to recognize or identify those cases where antenna go up, and we should be ready to do with as close to the level of thoroughness as maybe we would for a homicide is what I think sets the foundation for success in an evidence-based prosecution. And it means being, and although I hate the phrase proactive, it means being proactive throughout the litigation. The case, it means having all this evidence that's been gathered by your team, that's something more than just on the scene interviews of the victim and ideally the offender, but other folks involved and looking for other evidence to build the case. But then getting that record prepared and guarded in a sense pre-trial, getting your motions about admissibility of statements handled not in the heat or context of a jury trial or bench trial, but getting it litigated in motions and pre-trial hearings beforehand. Having the court educated and getting on what the issues were involved. So the court has the luxury of being informed about some of the intricacies of the law involved. Also, maybe educating your defendant or giving your defense attorney information in which to help the defendant understand what the scope of evidence is against them. Of course, the big challenge, and I know the one we're always scared about in the system, is what's the jury going to think about an intimate partner violence case where the victim isn't participating? And then maybe using jury selection to and we'll address this a little bit more thoroughly, but suss out and educate the jury about some of the realities of intimate partner violence. Part of an overlapping with and dovetailing with the idea of thorough investigation, trying to build our cases up and present our cases in court the same way we do with a homicide case, looking for these other, not just eyewitnesses to case, but folks who heard something, witnesses who can start building the entire picture about what happened in this incident. Expert witnesses, now obviously I say traditional, maybe that's not the best terminology, expert witnesses that might be medical experts.
Like any of our words today, John.
What? Yeah, I know. I have to take issue with some of them, but also educative efforts who can help the jurors understand some victim behaviors and victim dynamics. And while they're not there to talk about the particular victim, but help a jury become more fully informed about the realities of domestic violence, so a jury can make decisions based on reasonable doubts rather than unreasonable doubts.
So you premised that we're going to talk a little bit more about jury selection, and I'd love to hear what your strategy was, like walking into a courtroom. Like, what are your goals when conducting jury selection in these types of cases?
Well, obviously it depends on the case, but I want to identify and not shy away from whatever the challenges in my case are, and make sure that whichever members of the panel end up sitting in the jury box for my case can still understand the case, can still impartially and fairly evaluate the evidence, and still apply the law regardless of what their personal feelings are. So a lot of my voir dire strategy is going to be designed to start getting the idea, introducing the issues that might be challenges in my case to this jury panel and my eventual jury, and helping put them in context. Like if I'm going to have a victim who's not going to be testifying, I think on a basic level, I want them to understand that under the law, the victim isn't required to testify. And I want to find out if there's any personal feelings about intimate partner violence, that it's really just a private family matter, and find out things about that, and make sure I can get some promises from the folks who are going to be in the jury that I can remind them about in a diplomatic, artful way in closing argument. But I also want to start using this jury selection process as an idea to maybe introduce folks to some of the reality of intimate partner violence that they might not be familiar with, because maybe they fortunately haven't been exposed to it a lot. So they don't have a basis to appreciate the reality, and they can just sort of imbibe the stereotype. And that might be when permitted in my jurisdiction. Of course, any jury selection strategy has to be with that caveat. Like jury selection, what's permitted is individualized to jurisdiction and often to specific courts and judges. But if there's folks here who've had someone close to them ever been a victim of intimate partner violence, did that person stay with the offender? Did they report it right away? Did they always talk to the police? Did they go through with the prosecution? And with a big enough panel, I'm sure there's going to be some members of the panel who'll have someone close to them who's going to have what's not an uncommon intimate partner violence experience. And while the person who responds might be struck for cause or might not be eligible to be in my jury, that person's experience is going to help educate the rest of the panel as to what the everyday reality is of domestic violence, rather than the stereotyped ideal of how victims respond to intimate partner violence.
Yeah, I often think that, jury selection, you're starting to put the lens in front of the jurors, right? Like, this is how we want you to start looking at the evidence through this lens that we're starting to give you in jury selection, that will continue to give you through our opening and our direct examination of our witnesses and our argument, and maybe with experts, but like setting that stage and that foundation for it in jury selection. And I also appreciate that you acknowledge that jury selection just varies so widely.
Yeah.
So I'll take the opportunity to plug. This is a great place to reach out to AEquitas for your like individual cases, or your individual, limitations. We've worked with folks that have been developing questionnaires or all through the spectrum of allowable jury selection. So we'll plug that here as well. Okay, so we're setting the stage through our voir dire, but then we don't have somebody that's going to come in and tell us, this is what happened to me. So how do we bring the victim's voice into the courtroom if the victim is not physically there?
Well, Jane, your warning that we would be coming back to collaboration is coming to happen and coming true right here. Because I really think a lot of the opportunity to bring that victim's voice done is building good relationships with law enforcement to identify, seek out, and preserve and memorialize the kinds of statements from the victim that are going to be eligible to come into court, regardless of whether they're available. And helping a lot of law enforcement and first responders understand some basic principles with hearsay in the statements we can bring in and how we can prosecute cases. So then our investigators know what sorts of things to seek in preparation for the intimate partner violence case that might not have a participating victim.
Yeah, and I don't know if it's your pet peeve as well, but probably one of the, like, when I watch like legal dramas or TV or movies, and the way that people just throw out hearsay and everybody thinks they know what hearsay is. But it really is a complicated analysis of what is hearsay, what are exceptions to hearsay, and then we've got the Crawford on top of it. So I'd love it if you could sort of walk us through just first off the hearsay itself, and then we'll get into the other layers.
Sure, and I don't think it's unusual that for most legal educations or most 101 evidence classes is I think the hearsay component takes up the biggest portion of the semester because it can be so complex and so nuanced in many levels. But first of all, and I'm going to use the graphic here because I think that sort of lets it out or lays it out conceptually pretty well. But whether something is hearsay or not has multiple components. On its most basic level, it's a out-of-court statement offered for the truth of the matter asserted. But each of those components has to be broken down even further, and they have to be understood in a unified, holistic manner at the same time. But the statement, a statement's going to be something asserted, and that sort of dovetails with the truth of the matter asserted. But a statement can be something verbal, but it can also be a non-verbal assertion. The classic example is going to be he hit you, and if the person nods yes or no, that would be a non-verbal assertion that they were hit. It has to be something that was made out of court, made by someone other than the person who's testifying, because of course, if they're testifying, they can be cross-examined about out-of-court statements, and made at another time than during testimony. So in response to police officers, to lay witnesses, etc. But ultimately too, and this is not the only place where the trickiness of the analysis as to whether something is or isn't hearsay comes in, but it has to be for the truth of the matter asserted. And so why do we want the statement into evidence? What are we trying to prove? Are we trying to offer this statement to prove someone's state of mind, or that someone wasn't mentally competent when they said they were King Louis XIV? We're not offering that statement to say they were really King Louis. We're showing it to say they were not right, or maybe for some other purposes. So in other words, that helps us determine about whether the context in which it's being offered can tell us whether a particular statement is or isn't hearsay. And that's why we have to look at the overall, the complexity of the overlying context, evidentiary context in which a statement is being offered.
Yeah, I feel like in IPV cases, intimate partner violence cases, we don't do a great job of analyzing this last one, because a lot of, the accompanying statements of maybe like, what was the fight about that preceded an act of violence? Maybe there's an argument about finances or about child custody. And we if we're not really clear and making our arguments, hopefully outside the presence of the jury, to a judge that's like taking the time to make the analysis, all of those could be just like, oh, that's hearsay. That's something the victim said outside of court. Where in fact, what we're bringing it in for is state of mind, effect on the hearer, like what prompted. We don't care if rent was actually due on Friday. We care that this was a point of tension in a relationship that turned into something violent. And if we can articulate that, a lot of those statements should be admissible under this initial hearsay analysis. Don't you think?
I agree. The other complexity is that some jurisdictions, I know the federal version of evidence includes as non-hearsay defendant admissions or admissions of a party opponent. Some jurisdictions are going to call that an exception rather than not hearsay. Statements in furtherance of a conspiracy, which often isn't going to have a lot of relevance in intimate partner violence prosecutions. But yeah, I agree. Taking a deeper dive into these statements is going to help prove whether or not it's maybe something that's even asserted. I can remember, I don't want to identify someone particularly wrong, but I was trying to get a private investigator of the defense had been harassing and questioning a victim of mine. and I wanted to get that person's questions in. And it was objected to on hearsay because the questions were an out of court statement. And there was a misunderstanding, well, that a declarant's or person's questions, they aren't really assertions, so they can come in, and sometimes missing that component of the analysis. So this can get misunderstood a lot.
Yeah. And I think in digital evidence as well, is oftentimes where these statements are documented is through like maybe a series of text messages or things like that. And you'll get those arguments that the question, like the conversation, you have to kind of address both sides of it. So it can be really like parsing everything out, and different exceptions go to each one in piece of it. And then you also have, you know, an argument that you need to have the full record as well. So,
and you're going to have it overlapping, like for digital evidence, with authentication issues as well, and those challenges.
Which
this is why it's for the best. Yeah, this is why it's for the best prosecutors.
I know these are the common exceptions to hearsay. I think in my practice in DV, excited utterance was probably like most popular. And then some present sense impressions. Every once in a while, I'd get the play-by-play 911 call. We're going to touch a little bit on the medical diagnosis. That can be pretty important. Recorded recollection in a stalking case. We would often have recorded recollections because someone had maybe made a log or something.
I agree. Like, this is the main bucket of exceptions. And I think probably, obviously, we could take a deeper dive into each exception. What I'd recommend, though, is really be working with the officers you have to help them understand that these are the things you want to have your antenna up when you're responding to an investigation. Have your officers understand a lot of folks are using body-worn cameras these days. And so the opportunity to obtain recorded recollections or memorialized statements is a lot easier than it might have been 10 or 20 years ago, helping the officer understand, like, hey, look, you question people on the scene, even if they start circling the wagons later on or minimizing or recanting. And I'm not just speaking of victims, but third-party eyewitnesses, people affiliated with the offender. These are really useful things that can be offered later on for the truth of the matter asserted.
And I think when you talk about it as far as educating the officers, like this is another great place, is this extra level of Crawford. Because if we dig it down to testimonial, non-testimonial, a very simplistic way to say it is, in most occasions, if it's to law enforcement, it's testimonial, exceptions, of course. And non-testimonial would be to friends, family, neighbors. And so those are the ones we should really kind of say, hey, make sure you're talking to these folks.
Absolutely. And I mean, look, Crawford, our 2004 case, is recognizing that, hey, the confrontation guarantees of the Sixth Amendment, it trumps any hearsay exception if that statement's testimonial. And as you said, Jane, testimonial statement is going to be something made in preparation for litigation, like something usually made to a law enforcement officer. Now, there's exceptions we're not going to really dig out right now. But generally speaking, non-testimonial statements or statements, out-of-court statements, or statements given to lay people that weren't made in preparation for litigation, like to medical providers, which is why you probably always want to encourage medical care for your victims, to neighbors, family members, things like that. If there's an available hearsay exception, you're not going to have to go through a Crawford analysis, and which is why you're getting helping that understanding increasing by always looking for those statements that victims may have made to non-law enforcement people is going to make litigation of the evidence-based prosecution a lot easier. Yeah,
I was in a jurisdiction where I was really had the opportunity to speak with victims almost immediately after an arrest had been made. So oftentimes when I was speaking with them, one of my questions that ended up being more important than others was, who else knows about this? Who else have you told about this? Not only could I potentially get these admissible statements, but I also identified allies and identified folks that the victim trusted and that were maybe additional points of contact for me if I was having a problem getting a hold of the victim. So trying to figure out like who else in your life do you talk to about this? And then I realized even if the statements weren't admissible, I had one case where everybody at work knew about it because there was a stalking element as well. So of course everyone knew at work, and then there were work records that corroborated missed work after certain incidents that we had. So that ended up, for a lot of reasons, that question of like, who else do you talk to? Even if, ultimately those statements aren't admissible, I felt like that was a really good strategy.
You made me think of an overlooked area, that can sometimes be overlooked, and that is the child witness. Because I know a lot of times the well-intentioned proclivity of a lot of responding officers is, hey, I don't want to involve the kids in this investigations or wrap them in. But a lot of child witnesses, those are going to be non-testimonial hearsay statements. That it's going to be non-testimonial evidence about what happened or things that the victim said, especially if it was an excited utterance. And the opportunity to at least initially preserve that is going to be at the initial response. Now, that doesn't close you off from a decision about whether or not it's appropriate to call that child, whether it's going to be risking their safety later on. But at least getting that initial statement, I think, is critical because, of course, domestic violence, it's going to have so many risks to the development factors of children that are in that household, including to their development and the correlation. And it is just a correlation of them being involved in intimate partner violence later on. What I'm saying is, I think developing that, talking to those kids, finding out what they, if anything, they witnessed. So you have the option about whether they should be utilized for, can be called in a case later on. Mm-hmm. And you don't have to make a categorical decision about calling the kid as a witness.
Absolutely. And you can use, child advocacy centers, and there's lots of tools that have been developed to minimize harm in that regard and to maximize, children feeling, almost empowered by being part of the process and not ignored through the process. It's really interesting. I think slight shift from when I started doing this work. I feel like that at one point it was like an absolute no, and I feel like we're moving away from that.
Hopefully.
Yeah.
And again, you shouldn't make a categorical decision at that point, but you should have the option later on for both the kid's sake and the victim's sake and the offender's sake too, frankly.
Mm-hmm. So I think we kind of reviewed all of these, but this is like where to look for these statements that potentially are going to be, fitting this category of admissible, either non-hearsay or exceptions that are going to overcome a Crawford analysis.
The only thing I want to add is with medical witnesses, and just what a terrific fusion that is of victim-centered and offender-focused practices, because always urging and proactively making available medical services to victim, it's the victim-centered approach. It's getting them some needed medical care, even for injuries and trauma that might not be immediately apparent, getting them to take care of their health. It's, of course, offender-focused because the statements in most jurisdictions that victims are going to give to medical providers are going to be admissible hearsay. I mean, sometimes there's going to be caveats as to whether the identity of the offender can be offered or not. But again, contact us. But you talk about a mutual offender-focused, victim-centered practice. I think getting medical care for your victim is a reflection of that.
Yeah, absolutely. Absolutely. So I'm going to quiz you.
Oh boy.
Yeah. So I'm going to give you a scenario and then you're going to work through the analysis for me. You already did one with a medical professional. That was pretty simple. So I've got another one for you. So victim's neighbor is testifying, and the testimony that we want is victim's neighbor is going to say, oh yeah, about 6 months ago, neighbor knocked on my door. She was in a fit, bloody nose. And I asked her what happened. And she's like, he just went crazy. And And then I let her into my house, and she stayed overnight with me.
Okay. So the statement analysis, and I think you can do this in either order, but the hearsay one has to be in the middle. Well, you could flip it up a bit, but I like this order. So first, looking at the statement. So we have the neighbor knocking on the door. We have the victim knocking on the neighbor's door, appearing bloody, distraught. I think it's going to be fair to say she's excited, but that's the second part. Does a hearsay exception apply? Let's back it up a bit. Is it hearsay? The statement of the victim is he went crazy. On the one hand, I think you could offer, well, it's not being offered for the truth of the matter asserted. We're not trying to say he actually went crazy. So maybe there's a colorable argument. I don't think a credible argument, but a colorable argument that it's not hearsay. But I think we could concede that, hey, look, he went crazy is shorthand for he's the person that did this, that caused these injuries. So in that context, although there's a colorable argument, we could say it's not hearsay. I don't think that's going to be successful, and we probably shouldn't land on that. So we'd say it's not here. It is hearsay. He went crazy is shorthand for he assaulted me. So does an exception apply? The exception to hearsay, I think that would be in play. It's not present sense impression because she's not talking about it as it's happening. It's after it. But it does sound to me like excited utterance, given the context of the freshness of the injury and the distraught nature. And hopefully we solicited from this neighbor, what made you conclude our victim was distraught? What was she doing? You said she seemed upset. What made you conclude she was upset? Can you give us some descriptions? So I think you would have the excited utterance exception. Is the statement non-testimonial? I don't think our neighbor was preparing for criminal justice proceedings, so we can safely take it out of the Crawford umbrella and argue its admissibility to the court, regardless of whether our victim is available or not.
Nicely done. I put you on the spot there too. I always try to say, like, do we want the jury to believe he went crazy? And the answer is yes. I mean, I want them to believe that he assaulted her, right? For the first one. But I'm curious, because it came up in another training we were doing recently. They said, is there a chance the statement turns testimonial when neighbor says, yeah, come on in. Why don't we call the police together? Let's call the police.
I don't think it turns testimonial at that point. And the argument I would make is because one, when the victim, when she asked what happened, I don't think you could argue it was being prepared at that point for criminal adversarial proceedings, but to figure out what the heck happened. Why are you at my door distraught and with a bloody face? And I think at that point, there could be an argument that the what happened, even if it was an officer, you might be able to make a response under the Michigan case, the 2012 case, that at that point, it's just trying to figure out the state of an emergency. But I certainly don't think it's testimonial, even if the neighbor makes a decision afterwards to say, hey, let's call the police.
Yeah.
The Michigan case, whose caption I forget right now, but from 2012, but ongoing emergency, I think there's a colorable argument you could make that if the victim appeared bloody and distraught to an officer, that it's not testimonial because they just want to figure out what's going on.
For sure.
But the follow-up questions could transform it into something testimonial.
So, okay, so we're going to get all these statements and we're going to identify, we're going to parse them out, but we're still sort of left with this, potential vacuum that a jury's sitting there going like, why should I care? If the victim's not here, then why should I care? This doesn't make sense. If the victim was actually victim, they would be here, they would tell me. So there's all these sort of, what I like to say, this divide between a jury's expectation and the reality of domestic violence. And we talked about maybe setting the stage in our voir dire, but I wanted to turn to the use of experts. And I'm going to start by having you kind of parse out I mean, I've gone to the effort of highlighting the pieces I really want you to talk about here. This is
I know what to say now.
the federal rule. I think most states rule mirrors this pretty well. But when we're using expert testimony in this context, it's a little bit different than maybe we're used to if we're trying to get in, fingerprint evidence or DNA evidence.
Sure. Well, I mean, of course, just to sort of set the stage a little bit even more, victim expert testimony is a big bucket. And I think specifically what we're alluding to here is what I'm going to reference or term as victim behavior experts. And these are going to be experts who are there to educate the jury about the spectrum or range of responses that victims have to the trauma of domestic violence, of intimate partner violence, and some of the behaviors that can happen. And really the gateway for the admissibility is through the 702 or the 702 equivalent in your jurisdiction, which recognizes, despite common conceptions of experts being PhD folks with the pipe and tweed jacket on, legally speaking, an expert's going to be someone not just qualified by education, but also by skill, by experience, by training or knowledge, and or education. It doesn't have to be just education. And an expert can give a testify in the form of an opinion or otherwise, which means even if you don't have an opinion, you just want to educate about something specifically, if the specialized knowledge is going to help the jury understand the fact or the evidence to determine the fact and issue. And here is a jury's understanding the range of responses that victims can demonstrate to the trauma of domestic violence. And I sort of, the nature, although the metaphor doesn't work precisely, I think it does help to sort of conceptualize it for some prosecutors not used to working with victim behavior experts. It's sort of similar to drug trafficking investigations or constructive delivery investigations, where you have an expert witness testify about drug culture to help juries understand the context about whether maybe a specific controlled substance was possessed for personal use or for delivery or for trafficking or something of that nature. You get expert witnesses to help juries understand that. Same thing with domestic violence and intimate partner violence. People who have specialized knowledge can help a jury understand the range of responses of domestic violence victims, so that a verdict is only returned on whether or not there's a reasonable doubt, not whether or not there's an unreasonable doubt.
Mm-hmm. I think sometimes we have to also, to lay the foundation here for admission, we have to maybe look at some social science that says, despite a lot of education in the last 20, 30 years, there are still, myths and misconceptions that are out there and that lay people hold when it comes to domestic violence and what it looks like, what the reality is. And we do really specific training, doing a deep dive onto this in the context of domestic violence, context of sexual violence, the context of human trafficking. But it still is, this is a place where we may have to educate our judges to say, okay, this evidence is admissible. And if they're, used to using only excerpts when it comes to hard science, then we get these arguments about, well, this doesn't fit into Daubert or Fry. And so I think we've put a couple of resources here or cases here to help walk through that. But I think, as a prosecutor, you also have to be prepared to articulate that to your judge and maybe educate your judge.
Yeah, and then look, these are always the fun types of proceedings, especially when your judges aren't used to victim behavior experts. But look, I think when you're offering victim behavior experts as for an educative purpose, they're being offered not for some sort of scientific or technical expertise, which is where a Daubert or Fry or Cuomo Tire, or I think that's the caption, are going to be called into question, where you have to prove the reliability of the science. But something a little bit softer than that. And again, the comparison I'd make is something like a drug trafficking expert that you might call on, because that's something I think a lot of courts, especially courts or judges that are familiar with criminal context, can understand. And I think sort of can help the light bulb go up over their head about both the utility of victim behavior experts and why they're so commonly needed. One of the things, hey, look, if you're feeling cheeky ask the defense attorney, hey, if you'll stipulate that this victim response of recantation or minimization shouldn't be considered as a reasonable doubt, I don't have to call my victim behavior expert. Most defense attorneys won't stipulate to that, and probably you shouldn't be that flippant court, so I wouldn't always recommend that. But I think that kind of argument illustrates the utility of, hey, look, these behaviors of victims are not commonly understood, and if you're not commonly using these victim behavior experts with your judges, I think this is something ultimately, given the particulars of the case, it might be worth exploring it through interlocutory appeals for the admissibility, if that's a possibility in your jurisdiction.
And as I give you the question of, who can be this type of expert, I also wanted to plug the use of experts beyond trial testimony.
Well, that's it, and that's a great thing to
go back to collaboration by any chance.
It is back to collaboration, but it makes me think, like, something we haven't talked a lot about is these victim behavior experts. Ideally, the ones we present at trial, they're going to be blind experts. They're going to be experts that are not familiar with the victim or the discovery in the case, that are just there to talk about victim behaviors that are challenging generally and to help the jury understand those issues. But still, having someone with an expert understanding about victim behaviors can help us a lot. And so it's really useful if we have witnesses that we can touch base with to help identify the victim behaviors that are going to be challenging for a jury, help us understand them. And like by working closely with resources like our victim advocacy organization or community advocate to help understand these behaviors, so we can identify these issues for whatever expert we're going to use at trial. Ideally, we don't ever want to use as an expert agencies that our victim has worked with. And the reason why is because we don't want to compromise or create the risk that the bias or impartiality of our expert is going to be called into question, or that the expectation of privacy and confidentiality of our victim could be compromised either. But still, these folks are going to be great. Our own local community advocates are experts right in our own backyard that we can use to help understand our case, especially when we obtain a impartial, blind, or cold victim behavior expert.
Yeah, I think my ability to prosecute cases involving these sort of challenging victim behaviors was enhanced when I started building relationships with our victim service providers. And then I could sort of, even if it was like hypothetically, if I had a case where this was going on, like, what would you think? And I remember in particular, I had a case involving an intimate partner stalking, where there was communication documented from victim to defendant. And right, so, in my head, I'm like, well, if you don't want any contact from him, like, why are you calling him? And it seemed to be like every morning she would call him. And I'd be like, what is going on here? And it was a victim advocate that said, oh, she's taking his temperature. And I was like, what? And she's like, yeah, that's how she's keeping herself safe, is she's contacting him every morning and being able to read, like, if he's, what his mood was like almost. She goes, I bet you that's what's happening. Sure enough, that's what was happening. And I didn't understand that. Now, now I'm equipped. It doesn't fix my case, but now I was equipped to say, okay, now how am I going to deal with this at trial? How am I going to then educate a jury about that? How can I maybe, even without the use of an expert, sometimes it was just working with a victim who, was able to articulate that if I asked the right questions and if we worked together enough. So the use of the expert, I never even used it at trial. I used it for me to better educate myself, better understand the evidence, better communicate with my victim, and then better present a strategy.
So yeah, they help. They help make known the unknowns, or no, that's not phrased correctly. The things that we know we don't know, a community advocate can help us know.
So I've used folks that work at shelters, folks that work at rape treatment centers, some of your SANEs or nurses can serve as experts. Who else have you worked with in this capacity?
Well, I mean, obviously, in sort of touching base with something I think we might talk about later. Ideally, you can have someone that's a combination of heavily credentialed and heavily experienced as well, and then that those backgrounds are going to complement one another. But a lot of times it's what you talk about. Those types of experts, they're so valued. They can be pretty rare and take a lot of resources to utilize and not have as much time available. But yeah, area advocates or advocates from neighboring jurisdictions, they can really be really great in helping to understand all these issues. Ideally, you can set something up within your jurisdiction where maybe, hey, look, if you have a neighboring county next to you, they can utilize your advocates for their cases as victim behavior experts, and you can tap on theirs for experts in your cases. And it's a great sort of, hey, you can use your own experts for pretrial consultation and use the other jurisdiction's experts for testifying.
Yeah, I skipped to this slide because I realized that's where we were going with this conversation. And I think a combination is great. I always like to ask, because even if, well, first off, experts sometimes shy away from being identified as experts. Mm-hmm. We have like humble people that are not lawyers that are like, I'm not an expert. And you sort of sometimes have to talk them into, yes, you are.
They don't appreciate their own expertise.
Yeah. So, but a lot of them do have, advanced certifications or degrees. They also conduct a lot of training, a lot of cross training. So sort of bringing all of that out is important, and recognizing who may be effective in your case. And that could be because a judge is going to only perhaps recognize the expertise of somebody that has a little bit more credential, or it might be you've got a jury and you've got cases where somebody that's just on the ground doing this work, they're going to be really effective in this case. And a combination, and either or, both will usually work. But being a little bit thoughtful about it, if you have the opportunity to choose between, that's not always what we have. But I think it's another place where AEquitas has done a lot of work, which is building capacity. We've done trainings where we have the folks that are working in the service provision realm and the prosecutors do a training together and then do some mock testimony, hopefully to get everyone a little bit more comfortable with it, because it can be a little scary. So another plug for further reach out to AEquitas. I just had one more sort of question and wanted you to walk through, like, what does it actually sound like when you're trying to elicit this testimony at trial?
Well, I think the successful victim behavior expert, a big component of it's going to be setting the foundation for their expertise, putting in the number of victims and survivors they've spoken to and worked with and counseled. Maybe if you have a victim from a special population, maybe you're working with the victims who are undocumented, you'll have an expert who has a lot of experience in that area that they can relate to the jury. And just the scope of their expertise is then communicated to the jury, so that the basis for their subsequent testimony, the jury has a foundation for. But then you take the areas which you've identified as victim behaviors that are challenging in your case, or you think might be challenging for the jury to understand. You've identified those to your testifying expert beforehand, like, hey, can you talk about continuing contact with the offender? Or the example here, like delayed disclosure. And your victim behavior expert can be like, oh, these are the kinds of issues I've encountered dealing with delayed disclosures or dynamics that can impact that. And then just letting the expert know that even if they're not familiar with this individual victim or individual case, that delayed disclosure, it's not uncommon. And then the follow-up question to that about, in their experience or study or work, what are some of the reasons for that? It's like, well, there could be children involved. There could be because they're worried they won't be believed. Could be because they don't have a support network, because they've been isolated through a cycle of domestic violence, or financially dependent on the offender, a variety of reasons. And as the expert goes through generally, what are some of the reasons for delayed disclosure? Hopefully you're going to see the light bulbs going above your jury's head as they recognize, oh, wait, That's what the victim has in this case. And that's what the prosecution brought out with this case. Like when that victim was got on the stand and said, I really overblew it, nothing happened. But the prosecutor then asked her, do you have any family in the area who provides support for your kids? These are the same challenges that this expert's talking about that victims faced in her experience as the victim in this case is facing. Mm-hmm. And the jury's going to feel like the genius for making the connection.
Yeah, it inevitably does, but it lines up. And so you've got somebody that has, you're laying that foundation. They don't know this case. They don't know this victim. They haven't reviewed any of their reports. They're just saying, this is in my practice, is what I've seen. This is common. This is really, not uncommon. And then everything they say lines up with the evidence. And it's like match, 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 match. And then you can dial down into something. If, let's say, what are some of the reasons for delayed disclosure? And they mention, lack of family support and reliance on maybe the offender's family for financial support or childcare support. Then you could ask even one more question. You mentioned the lack of child, care. Can you explain how that impacts it? And then they could maybe even go into a little bit deeper once they've, kind of the funnel effect almost.
Mm-hmm. Great way to point it out.
So, but there are some danger zones. I think we want to be recognizing, and some of these are, I think, pretty obvious. We don't want an expert to say it is my legal opinion that the defendant is guilty and a batterer. But and bolstering credibility, and that helps just in the way that we present it in this blind testimony way. But I'm curious about the diagnosing victims piece and the neurobiology piece, because when I read old case law, I do often see, good case law that talks about, oh, this is, the expert talked about this victim having, batterer woman syndrome or rape trauma syndrome or something like that. But we're moving away from that.
Right. And that was a window or lens which a lot of jurisdictions recognize the admissibility in the late 80s and early 90s. And I think we've gotten away from that because, one, a lot of the sort of symptoms can be caused or related to things other than being a battered person. Another reason is that we don't want to sort of label victims of domestic violence as sick or being inappropriate, or set up an avenue where, hey, gee, you say they're acting this way because they have some diagnosable syndrome or physiological syndrome. And then the defense says, I want to see everything about their medical records and personal records and counseling records and mental health records to see if there's anything that can be contested about that.
Or I want them to be
examined by my expert. I'm sorry, I stepped on your line. I'm sorry.
Okay, you're here for that.
I got so excited by the point you made. I was like, oh yeah, such as.
But the last one where I have sort of the cautionary tale, the cautionary yellow, is the neurobiology of trauma. And again, this could be its own training, but I know you can concisely.
Yeah, sure. Well, first of all, I think by having a victim behavior expert explain a victim's behaviors in the context of neurobiology of trauma, you're creating risk that you don't need to do. Because first of all, you can explain victim behavior just by anyone who has experience working with victims, and just these are the realities and these are the reactions, and it's not uncommon. Basically, most victim behavior experts, I think the real thrust of their testimony is going to be, you may have expectations of a typical victim response. There is no typical victim response. And these are some explanations for responses you might not consider intuitive. Neurobiology of trauma is one sort of profiling victims into that sort of umbrella. It's challenging because, one, neurobiology of trauma, while it can be very helpful for us during investigation to understand victim responses, it is something that's still very much developing and in a lot of context. And I think the kinds of experts that would be qualified to actually decisively speak about neurobiology of trauma would be someone who has a PhD in neurobiology and also has experience with working with survivors of intimate partner violence. The population of people who have those, who meet that Venn diagram of circles of expertise is probably like 10 people in the country. And I would suspect that most of them are very expensive. So you would have a lot of expense or a lot of risk to properly explain or to try and explain victim behavior when I think there's a lot easier ways to do it that are unnecessary and that don't have to rely as much on a field that is developing.
And I think this is something to talk to your expert about because like you mentioned, neurobiology of trauma and the tenets, and a lot of us have received training on it. And it has aligned with a lot of the things that we've absorbed through our experience. We've observed. So it's kind of matching up with our experience working with victims over the years. And so it can be really informative. But what I see and hear about is a defense line of inquiry trying to sort of get somebody that has received training on neurobiology of trauma, trying to get them to sort of put themselves as an expert in that field. And I feel like that's a real danger zone as well. So was reported that a defense attorney asked an expert that was testifying through experience, through like, you know, what we talked about, the more anecdotal experiential, and they said, oh, have you received training on the neurobiology of trauma? And the person would say yes. And then the defense would ask them questions about actual neurobiology, and it would get into this messy land. So I feel like it's just easier to talk about it in the broader terms of this is my experience working with victims. These are common behaviors. And yes, I've received neurobiology of trauma, and a lot of it makes sense in regards to my experience, but I am not an expert in neurobiology of trauma.
Yeah, and what a great way to sort of just stop it. And that's expertise based on experiential background. It's a lot harder to impeach in a lot of ways because, you know, that's my experience. What do you want me to tell you, buddy?
That's true. So yeah, that's, but you know, this is definitely another place where AEquitas has done a lot of work where I think you are writing something on this right now that's not published, but you are a wealth of expertise. And so if you want to reach out for more information or talk through some of these issues, please do. And going forward, think about how, no matter how your jury selection is conducted, think of it, how you can make it an opportunity to start that education of your jury, instilling empathy in cases where maybe a victim is not able to participate. Parse out all of those statements and look through the lens of hearsay, not hearsay, you know, exceptions that might be relevant, and then those non-testimonial statements, and making sure our officers are also looking for those and documenting them. And then as appropriate, offer the expert testimony to provide the context and to explain victim behavior, and do it in the right way, which is really offering it as an educational tool for both your judge and your jury, going to avoid those danger zones, I think, that way. So that's it. Jon, thanks so much for lending your expertise today and for all that you're doing. Thank you guys. Always available to be in contact. And we've got these office hours we're offering the third Thursday of every month for prosecutors to get together, share resources, network. I know, Jon, you lead many of these with different topics every week. So register here and learn about those as well. Thanks, Jon.
Thank you, Jane. Wonderful conversation.